As we commented in our last post, the candidates for president did not recognize Law Day celebrated on May 1st of each year. This year marked the day's 50th anniversary. Senator John McCain waited a few days until May 5th to give a speech at Wake Forest University in Winston-Salem, North Carolina, where the presumptive Republican nominee declared his judicial philosophy and opposition to a judicial analysis which dates back to 1923, establishing that a right to privacy exists within the United States Constitution. McCain said that the courts should play no role in making social policy. Does this mean he disagrees with the court's decision in Brown versus the Board of Education and its progeny, for example? He disagrees with the court ruling that the murder of a 17-year-old by the state of Missouri did not constitute cruel and unusual punishment, and criticized the court for resort to international law and evolving standards of decency, since we are one of the few advanced countries in the world to practice capital punishment. Without these evolving standards of decency, Plessy versus Ferguson would still be the law of the land. The most troubling statement by Senator McCain was his reference to meditations, where in the traditions of penumbras and emanations and other airy constructions the court has used during the years as poor substitutes for clear and rigorous constitutional reasoning. The United States Constitution contains no express right to privacy. The Bill of Rights, however, reflects the concern of James Madison and other framers for protecting specific aspects of privacy, such as the privacy of beliefs in the First Amendment, the privacy of the home against demands that it be used to house soldiers in the Third Amendment, privacy of the person and possessions as against unreasonable searches, the Fourth Amendment, and the Fifth Amendment's privilege against self-incrimination, which provides protection for the privacy of personal information. In addition, the Ninth Amendment states that the enumeration of certain rights in the Bill of Rights shall not be construed to deny or disparage other rights retained by the people. The United States Supreme Court Justice Louis Brandeis, in a 1890 Harvard Law Review article on the right to privacy, wrote, quote, "Political, social, and economic changes entail the recognition of new rights," close quote. One of these rights, he proffered, was the right to be let alone. In a string of cases, the court accepted a common law right to privacy, particularly where it contained issues of mores. In the 1950s, the Supreme Court began, in cases of criminal prosecution, raising questions of improper actions of government office, to talk of a constitutional right to privacy which protected individuals against such acts. In 1965, the Supreme Court in Griswold versus Connecticut held unconstitutional a statute to deny birth control to married people. In 1972, the court used equal protection to allow birth control to unmarried couples. Later, the Rehnquist court held in Lawrence and Gardner versus Texas that a Texas sodomy statute was unconstitutional as a violation of privacy rights. The opinion was written by Justice Kennedy. Whether you agree or not, the court in Webster and Casey did establish an exception to privacy regarding children when it upheld Missouri's parental notification statute regarding the right of young women to receive an abortion without parental consent. Would Senator McCain's judicial philosophy mean a test for his judicial nominees be the overruling of cases following a line of precedent dating back 60 years and has become ever more important with regard to domestic spying and other eviscerations of Bill of Rights and civil liberties in the war on terror? In his speech, he seemed to say as much. This is Joe Garcia. The site is reform.squarespace.com, reform.squarespace.com. The email address is reform.gmail.com, reform.gmail.com. Thank you. Have a pleasant tomorrow. Good night.